years after the murder of 13-year-old Tristyn Bailey, her family had a chance to address her killer in a Florida courtroom. Now 16-year-old Aiden Fucci faces 40 years to life in prison after he entered a guilty plea in the gruesome stabbing death of Bailey on Mother's Day in 2021. Bailey was originally reported as a missing person before a jogger ultimately found her body. In his first interview with police, Fucci said he only pushed Bailey, causing her to fall down, but the medical examiner found that she had been stabbed more than 100 times, and part of the murder weapon was actually broken off in her skull. During sentencing, an ME said that defensive wounds on her arms and hands showed that she was fighting for her life. The prosecution also called a psychologist who said Fucci detailed a hypothetical murder to his peers before Bailey's death, suggesting possible premeditation. Victim impact statements finished off the state's case on a very powerful note, and in the defense's case, Fucci's grandmother also addressed Bailey's family. Take a listen.
114. This jar now holds 114 stones, one for each of the 114 stab wounds that my sister had to endure. The number of questions I have for Aiden Fucci surrounding that night plague my mind. Did she see you coming at her with the knife, or did you stab her while she wasn't paying attention? Did she scream out for help, or was she paralyzed with agony? Did she cry for my mother? Did she beg you to stop? Did you hear her lungs gargling with blood? Or did you see it in her face when she realized she could no longer breathe due to her collapsed lungs? What were her last words? Did you stay to watch her die? Or did you leave her there in agonizing pain as you ran away? Please consider everything that he has done to our daughter and to our family. Aiden Fucci made a heinous decision on May 9th, 2021, and took the very life that I brought into this world. Please do not for 1 second think that he could be rehabilitated at any point. He is beyond saving.
I just want to say to the family, I'm so sorry. I wish I could change what happened, and we pray for you every day. I pray for you every day. I pray for my family every day. And I just hope that you find peace somewhere, and just know that he has a good family, and we miss him, and we lost a child too.
Wow. You know, Brian, every victim impact statement's difficult and powerful, but do you think there's any one that stands out to you that may weigh especially on the judge?
I honestly wanted to pick one. I wanted to say that no parent, no mother should bury a child. It shouldn't happen. I wanted to say that the sister's use of questions about wanting to know about her sister's final moments would have been the one. Or the medical examiner recounting the 114 stab wounds and how her last moments would have been. Or the fact that part of the murder weapon was still stuck in her body as he callously walked away. Or the fact that he supposedly planned this with a type of murder. And I wanted to pick one, but no, there is no one. They all weigh heavily on the hearts of anyone who listened to this, and I think it's going to weigh heavily on the judge.
Well, that was my question, Nima. I mean, clearly this is important for all of them to be able to speak out, but how much does it actually play into a judge's decision? Because doesn't the judge already have a sentence in mind?
I think it does, especially in a case like this where you have a guilty plea. So normally you have your guilt in your penalty phase, right? But in a case like this, you jump straight to the penalty phase. He pled guilty, he admitted to the first-degree murder, that premeditated murder. It kind of reminds me of Nicholas Cruz, also there in Florida, Parkland school shooter, where you have this sort of elongated sentencing phase where a lot of these gruesome facts about the murder are going to come out that typically don't come out in a penalty phase because you deal with it in the guilt phase. And I think the judge is going to not only focus on the facts that Brian talked about, but those selfies in the police car afterwards. Yeah. I mean, that's pretty gruesome stuff.
Yeah, the callous nature of that and all this attack. When we come back, does freedom of speech mean the freedom to mock? Well, that's what one dog toy company says. It's in their fight against a whiskey-making giant. Up next, we're going to explain the bizarre Supreme Court case. right, welcome back, everybody. So we end today's show at the United States Supreme Court, which has decided some of the most important legal matters in our country. And on Wednesday, the court heard a different kind of case in a showdown between Jack Daniels and Bad Spaniels. That's right. The whiskey company is suing dog toy manufacturer VIP Products, LLC, for allegedly violating federal trademark law. You see, the dog toy version of the alcoholic beverage is part of VIP's Silly Squeakers line made to resemble real-life products. The Jack Daniels bottle has Old No. 7 Tennessee Sour Mash Whiskey beneath its trademark name, while the Bad Spaniels toy version says the Old No. 2 on your Tennessee carpet. Now, the district court originally thought that this spin on the whiskey bottle could actually confuse consumers, but VIP ended up winning their appellate case. So now the Supreme Court is going to have to determine if third-party humorous use of a brand's logo violates federal trademark law or deserves protection under the First Amendment. So Nima, I'll start with you. What did you think of Jack Daniels' argument that VIP is misleading consumers and using Jack Daniels' good name? One's a liquor company, the other's for dog toys. Not the easiest case.
Not the easiest case, but when you're dealing with these types of trademarks, intellectual property lawyers tell you, you gotta police and protect your mark. That's why Jack Daniels is talking about that likelihood of confusion. Of course, we all know as lawyers, that's the legal standard here. But really, is anyone going to be confused here? This is clearly a parody. I don't expect Jack Daniels to get into the dog toy business. So I would side with the defendants here, obviously the appellants, and probably rule against Jack Daniels if I were the judge ruling on this case.
I'm just going to present the counter argument there. That might be somewhere they expand, different merchandise. It's commercial. They're selling a product. It's not like it's just a parody. It's not like it's just they're doing it as editorial fun. They are selling something here. Now, Brian, I'll turn it to you. VIP says they're protected by the First Amendment. That isn't a trademark issue. So what about the freedom to mock? Is that a strong argument?
I like it because it moves the argument away from a field that they probably don't want to be in, and that's that this is a trademark issue. That the likeness of the toy is so close to that of the actual bottle, even though there is a Bad Spaniel, there's a dog, it's number 3 instead of 7, all the little intricacies that we whiskey drinkers know that we typically see from a Jack Daniels bottle. I think it is a mockery. It's a joke. It's a parody. It's fake everything. And so I think that argument and separating themselves from a trademark makes it stronger for them to say there are other case laws, whether it be spoken product. You bring up a good point. The commercialness of it does change it. It's not just some late night TV show making a joke about it. But I think it brings them into the realm where they have a stronger argument that this is a joke and not just a commercial product.
A lot of people don't know this. I used to practice trademark law. I think there's some consumer confusion there. I think I could see the argument, but that's my take. Nima, Brian, thank you both so much. Everyone out there, thanks for joining us here on Law&Crime Daily. We are going to see you next time as we discuss justice in America.